Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some legal news and insights they can use in their practice. As always, we're very grateful if you find this podcast helpful to recommend it to a colleague.
Yeah, if you find it unhelpful, recommend it to a spouse as a natural sleep remedy. Before we jump into this week's discussion, we want to thank Casetext for sponsoring our podcast. Casetext is a legal technology company that has developed AI-backed tools to help lawyers practice more efficiently since 2013. Casetext is relied on by 10,000 firms nationwide, from solo practitioners to American Law 200 firms and in-house legal departments. In March 2023, Casetext launched CoCounsel, the world's first AI legal assistant. CoCounsel produces results lawyers can rely on for professional use, all while maintaining security and privacy. Listeners of our podcast enjoy a discount on Casetext basic research at casetext.com/CALP. That's casetext.com/CALP.
Now, Jeff, both you and I are private practitioners. All of our clients, we expect to get paid in cash money by our clients, and our clients tend to seek cash remedies in at least our business litigation cases. But with our last guest, we talked about litigating important constitutional issues and public interest issues, and I thought we'd carry on that discussion. And we are privileged today to have Chris Schandevel to the show to talk more about what it's like to litigate and appeal cases at some of the highest levels in state and federal courts. Chris Schandevel serves as senior counsel on Alliance Defending Freedom's appellate advocacy team. As a constitutional appellate litigator, he represents ADF clients of all stripes on appeal, preserving lower court victories and seeking to overturn unjust results. Since joining ADF 4 years ago, Chris has briefed and argued cases in various circuit appellate courts and state Supreme Courts. He was on the team of attorneys who successfully represented the Thomas More Law Center in the U.S. Supreme Court, and he regularly represents clients in friend of the court briefs. We would call that amicus briefs, but we don't know how to pronounce that word, Jeff. Amicus briefs filed in state and federal appellate courts and in the U.S. Supreme Court. Before joining ADF, Chris served as an assistant attorney general in the criminal appeals section at the Office of the Attorney General of Virginia, where he helped brief and argue dozens of appeals in both the Virginia Court of Appeals and the Virginia Supreme Court. And before that, Chris clerked for the Honorable Stephen R. McCullough of the Virginia Court of Appeals. Chris, welcome to the podcast. Thanks for joining us.
Thanks, Tim. Thanks, Jeff. It is a real thrill and treat to get to be on with you guys and kind of nerd out on some appellate law issues. I honestly couldn't think of a more fun way to spend this Tuesday afternoon.
Yeah, well, we are a very weird and strange breed, Chris, but we are pleased to and also excited to talk about some of your experiences, which are very exciting to talk about with your Supreme Court experience. I watched your oral argument in the Massachusetts Supreme Court. We'll talk about that a little bit later, but just to get to know a little bit more about you personally, reading from your bio, it seems like you may have crossed several things off of your career bucket list already. Is that true? And what do you have in store?
Sure, I have, and to be honest, it wasn't a career bucket list when I set out to accomplish what I have. I went to law school hoping to do constitutional litigation of some sort, but not really thinking I would end up doing appeals. I had friends in law school that were, they'd done speech and debate in college. They were great professional debaters. I didn't even know what Robert's Rules was. So I definitely, didn't try out for moot court, didn't do any of those things. I kind of assumed that it was for the other classmates of mine. And then ended up getting a clerkship on the Virginia Court of Appeals, as you mentioned, straight out of law school. That allowed me to see the practice of law at the appellate level and really fell in love with the way that the law is litigated at that level. That led to an opportunity, as you mentioned, in the State Attorney General's office doing criminal appeals, which I also really fell in love with. Getting to argue 60 Court of Appeals arguments in the State Court of Appeals and 14 in the State Supreme Court in my first 5 years of practice as an attorney is just very rare from what I'm told. and was just so many incredible learning opportunities. Just really loved it and got a lot out of that. And that led to where I am now at ADF, really doing my dream job, doing appeals in areas of the law that I'm really passionate about and interested in.
Yeah, I had a question. Did you ever, I mentioned at the top that both Jeff and I, do private practice. We are in awe of attorneys like yourself who do public interest work. It's something that we admire from afar. Did you ever consider doing private practice, or did you always want to do public interest work and government work?
So I always wanted to do public interest work and government work going into law school. In law school, looking at the mound of law school debt that was going to face me once I graduated, I kind of did my best to convince myself that maybe a summer at a law firm and maybe a couple of years at a law firm wouldn't be too bad, make some money, pay off the debt. I'm not sure I ever really convinced myself that I wanted to do that. And I certainly didn't convince my big law interviewers when they were interviewing me that I wanted to do that because I did on-campus interviews, got one call back, but no offers to go to do a summer with a law firm my second summer. So that's what led me to the unpaid internship at the Virginia AG's office. And they told me, this is not an opportunity to get paid, number one. It's not an opportunity to get a job straight out of law school because they weren't doing a lot of hiring straight out of law school. So they said it's really a chance to get some good experience, meet some people, make some connections. And I ended up working with an attorney while I was there on a giant doc review project in the basement of the governor's building there in Richmond, Virginia. And at the start of the week, it was me and 10 other interns working on that project and a couple of attorneys. By the end of it, everyone had dropped off except for me and one attorney who kind of hung in to the bitter end. And made a good connection with him, good relationship, and found out at the end of it, little did I know, the entire week we spent working together, he had just been appointed to be on the Virginia Court of Appeals. And this is while I am submitting my clerkship applications and getting rejection after rejection. And so quickly reached out to him, asked if I could apply, and he was very gracious, allowed me to do that, and then ended up clerking for him. So that's kind of what started the process. But yeah, I've never had to bill a client in my 9 years of practice. I wouldn't even know where to begin with that.
Well, you touched on something that I did wanted to ask you about along that vein, about you're coming out of law school, you're looking at law school debt and looking at some ways, how do I pay this off? How do I maybe own a home and start a family and things like that we all think about when we're starting off on our career. And it reminded me that when the UC, the University of California system here started a law school in Irvine about 10 years ago or so, and I remember their first class, maybe the first couple of classes, they didn't charge tuition of their students. I remember the dean at the time, Erwin Chemerinsky, was very proud of the number of their law graduates who were going off onto careers in public interest law. And I thought, well, that's easy to do when you don't have any tuition loans to pay off.
Right.
Most of us have enormous loans to pay off. And how big a factor is money? It was a factor obviously for you, but you were able to overcome it. Is that how are you able to overcome it? And do you see more good-hearted attorneys who would like to do public interest law but are kind of forced into the slot of doing billable work?
Sure. So when I went to law school, I went to UVA for law school, and a lot of folks go to law school and get a lot of scholarship and manage to find ways to limit their costs in law school. I got into UVA and was honestly just happy to be there. So I did not get any scholarship help. So in speaking with friends and folks who had been through law school themselves, was told there's really a couple ways to deal with law school debt. There's the big firm route and kind of live below your means for a few years and pay the debt down that way. But if you want to go public interest, there is the public service loan forgiveness path. And so I first thought I would go the firm route and pay it down that way. When that didn't work out, I started pursuing the public service loan forgiveness path. And the way that the system works right now is you make your payments for 10 years and they're kind of adjusted based on your meager government salary. So you don't pay quite as much per month as you would if you were working at a firm. And then the 10 years go by and you're kind of living on a hope and a prayer that Congress isn't going to pull the rug out from under you at some point in those 10 years. But I'm just now coming up on my 10 years, and so knock on wood, all so far has gone well. So hoping to having given back through the public interest work that I've been able to do, hoping to have those loans forgiven here shortly. So that's been the path that I took.
Yeah. Well, and it's enabled you to have a very successful career so far, litigating a lot of high-profile, constitutionally significant cases. Has all that left you enough time to for a personal life? And what are some of your favorite ways to spend your personal time away from work?
It has, for sure. So, when you're working in government, one thing that you learn pretty quickly is that the reward for good work tends to be more work. So I stayed pretty busy working at the AG's office, but I did have the flexibility and the freedom that no one was there at 5:30 making sure you were still chained to your desk, cranking out briefs and memos. You really had the flexibility outside those normal business hours to go home, have dinner with the family, maybe do some more work in the evening once the family's gone to bed if you need to, and that's really carried over to the position I'm at now with Alliance Defending Freedom. ADF is very family friendly. Their position is that there's really no more important work that a mom or dad can do than the work that we're doing in the home. So there really is a big emphasis placed on getting home for family dinner, that you really shouldn't have to miss a family dinner. And so our office actually clears out around 5:30 every afternoon, evening, and everyone goes home and spends time with the family. Now you might get a flurry of emails between 10 p.m. and midnight from attorneys logging back on once the kids are in bed, and that's something that I've done my share of. But yeah, so I have 4 kids. They're ages 6, 4, 2, and 5 months, a daughter and 3 boys. And so that's how I spend the vast majority of my time outside of work, is just playing floor hockey with them in the living room, eating dinners together, going on trips, etc. They really keep me grounded and bring a lot of joy to my life.
Yeah, they will definitely keep you grounded and keep you humble.
Yes.
Yeah. You mentioned about that flurry of emails, a flurry of activity, after hours, after the kids are to bed, and some of the attorneys log back on and do some of their filings before the 11:59 deadline. And that brought to mind the news out of the Third Circuit that you may have heard about, that they're going to start implementing a 5 p.m. cap on filing. So if a filing is due on January 2nd, that means 5 p.m. on January 2nd, not 11:59 on January 2nd. How do you think that will change habits and customs at your office if attorneys are logging off at 5:30, knowing that, okay, I'm going to go home and have dinner with the wife and kids, and I'll just get that filing finished up and filed at 10 o'clock after the kids are in bed?
Yeah, I saw that, and I wasn't sure how to feel about it. My initial thought was, oh great, if my filing deadline is bumped back by however many hours that is to 5 p.m., I have to pull the all-nighter the night before I otherwise would have stayed up late to get that brief done. So it's just going to mean a later night earlier in the week for me. But as I thought about it and kind of read some of the commentary on it, I think the genuine motivation behind it was to allow attorneys to have a little more work-life balance, to be able to check out at 5 p.m. and know that the brief was done, the brief was filed, and it's time to go home and spend time with the family and have that life outside of work. So if it can really have that effect, then perhaps it'll end up being a good thing in terms of work-life balance. If it just has the effect of kind of squeezing everything earlier in the week, earlier before the filing deadline, maybe it won't have that. Maybe it'll backfire. So I imagine they'll let it go for a good year or so and see how things play out. And I'm sure other courts are kind of watching to see what happens there in the Third Circuit.
Yeah. So we'll have to take a wait and see approach to see if the stated goal of that new rule, which is to help foster a better work-life balance, if that goal is actually furthered by this initiative or new rule. Yeah. Now, when we had talked offline, you had mentioned about some of your experiences in public interest work, and how you have been blessed and privileged to always feel that the cause that you're representing is something that you're personally aligned with. That's another difference that Jeff and I may have with public interest lawyers, that, sometimes, the first thing we do want to make sure that our client has a legitimate claim. And then the next thing, we want to make sure that they can pay their bills. But whether we align with their cause is a distant consideration sometimes. It would be nice if we could always make that line up, but it doesn't always. Are your clients always in the right as far as you're concerned?
I would say that, well, first of all, there are no perfect angels in the world. We're all flawed human beings, right? So we all have our faults, myself included. But just like I said earlier, I've never had to bill a client in my 9 years of practice. I've also never had a client, had a case where I felt like the client that I was representing was morally in the wrong. I've always felt like the issues that are on the table, the case that's being litigated, I have been on the side of good, and my clients have been in the right. And that's really a special and unique privilege. I mean, you say, so I did before law school, back in high school, I did a lot of fast food work. I was a A&W Long John Silver's guy, and did a lot of manning the drive-through and talking to customers. And the old saying is the customer is always right, because they're the customer, right? And I think when you have paying clients, there's probably, I don't know, you guys can speak to this more than I can, but there's probably an extent to which the client is maybe not always right, but the client is right because they're the client, and you need to do what's in the best interest of the client. Whereas I feel like in public interest work, the work that I've been able to do, more often than not, the client is the client because the client is right. And that's a unique approach to practicing law and relationships with our clients, where I feel like not only do I have the duty to the client that I would have, in any other case as an attorney, but I also believe in the cause that the client is standing for and advocating for. And so that brings an extra, incentive to really give it my all and speaking for them and advocating their cases.
Yeah, that's right. That reminds me of one of my favorite quotes that I've never been able to find if it's actually attributed. It's attributed to William Jennings Bryan. I'm not sure if he actually said it, but it sounds like he might have said it. He said when he was confronted with the question of the free silver movement, and he said, and he was a candidate from Nebraska, and he said, "Well, the people of Nebraska are for free silver, so I'm for free silver. I'll look up the arguments later." Right. Look, every cause needs to have an advocate. If they don't have an advocate in the public forum, advancing those advocates, in legitimate ways, then you're going to have a lot of people who have a legitimate opinion but don't have a legitimate way to voice that opinion. And so that's the purpose of lawyers and politicians, for that matter.
Yeah, right. There's a criminal defense lawyer, I can't remember his name, who has a saying. It's one of my favorite sayings. He says, "If I only defend the righteous, what tools will I have to defend them with?" And it comes up a lot in free speech cases when you do anti-SLAPP work. There's people all the way on the left and all the way on the right and everywhere in between, and they all have free speech rights.
Yeah, absolutely. And as a criminal attorney on the prosecution side in the state AG's office for those 5 years, I was always so grateful for the defense attorneys on the other side who cared about the work that they were doing and did it well. Because the odds of getting to a right and just outcome increased exponentially when the attorneys on both sides are doing their best work.
That must have been an incredible adjustment for you. For 5 years, you were representing the state and the power of government and those deferential standards of review. And you were more often than not, I'm guessing, the respondent.
Yes.
Meaning the other side of the appeal. Going from that kind of practice of law to, oh my God, I'm now the appellant and I'm looking to change the law rather than, let's just say, apply well-settled principles. How did that adjustment play out for you?
It was definitely an adjustment. I've gone back and looked through my Westlaw sites to cases I litigated, and I probably had an 85 to 90% win rate at the AG's office. But again, if it's a criminal appeal, we won below, right? And we don't get to appeal when we lose a jury trial.
True.
So that definitely changes those deferential standards on appeal. So I probably litigated 6 or 7 of those cases were cases where I got to be the appellant at some point in the process, either a pretrial suppression ruling, or maybe we would lose in the intermediate appellate court and appeal that case up to the state Supreme Court. And to be honest, I always really loved the challenge of being in the role of the appellant and having to, persuade this, panel of judges or justices that what had happened below was legal error and was incorrect, and that the court should reverse that, because it does feel like it's a more satisfying win, I feel like, when you can kind of flip the script and get a result reversed. Right. So one of my favorite experiences in court, there was a time I was arguing 2 cases in the Virginia Supreme Court back to back on the same morning. And we were the appellees in the first one. We say appellees and appellants here in Virginia. So I was the appellee in the first, and then the appellant in the second. And the first argument, the appellant used up all of her rebuttal time. And so I literally gave my 15-minute spiel as the appellee, went back to counsel table, gathered up my books, walked across the courtroom to the other counsel table, put them down, went right back to the podium, and launched into my argument as the appellant in the second case. But I loved the challenge of, explaining to a court what, where the error was in the decision below, and trying to persuade the court to reverse that decision. Because that's I think it's hard for judges to do sometimes, because, judges at all levels are very bright and very smart, and for the most part, just trying to get the outcome right. And for a group of judges to have to say that another judge erred, and not just I would have decided differently, but erred to such an extent that it's either an abuse of discretion or a legal error and it has to be reversed and sent back, that can be a tall ask. So it was definitely a different challenge when I was in that position at the AG's office. It's been very different coming to ADF. We have been the appellee or the appellant more often than the appellee in a lot of my cases. And so that has been different. But again, it's been a fun challenge, and I've really enjoyed it.
Interesting. How common are issues of waiver and forfeiture, record preservation in your work with PLF and in your public interest and constitutional litigation? They come up all the time in the work that Jeff and I do, and we report on those cases as they arise in California Ninth Circuit all the time. Are they as prevalent? Do they come up very often in your cases? And do you have, and for that reason, for the reason of making a record, do you have appellate counsel consulting with your trial attorneys to make sure that, hey, this is obviously going to go up to on appeal, and we need to make sure that we've got all these important issues preserved?
Sure. So they're definitely common. I've been joking with my colleague recently. We both kind of feel like we came to ADF to do constitutional litigation on these big issues of free speech and religious freedom, and we've kind of turned into Article 3 standing attorneys more recently, because so many of our cases are being litigated on standing grounds. Yeah. Either, sometimes that's, us as the plaintiffs kind of, defending claims that we don't have standing, or it's us on the defense side making the argument that the plaintiff across the V from us didn't have standing to bring their claim. So we've certainly been litigating a lot of those threshold issues and arguments in our own cases. And the benefit of being at ADF, one of the neat things about the way that we're structured and the way that we do our work, so we don't do a lot of cases like jury trials, bench trials. Not many of our cases quite reach that level. They tend to get resolved, motion to dismiss or summary judgment. But we do have a teams of trial attorneys, and our teams are kind of broken down into subject matter areas. So we'll have like a free speech team. We'll have like a conscience team that does like more religious freedom, academic freedom, parental rights, or pro-life team. And those are the trial level experts that litigate the case at that level. And then we've got the appellate team that will come in and kind of assist once the case gets up on appeal, once we have a decision below. But those teams are really good at having conversations with us appellate folks throughout the process when potential issues of waiver or issue preservation come up. And they're also very good. So ADF for a long time didn't have an appellate team. So the trial attorneys who have been litigating these cases at the trial level for the longest time were litigating their own appeals. So they got to be very good at spotting issues that might, preservation issues, waiver issues, and making sure that those were all covered before we got to the appellate level. So we're very blessed just to have the level of expertise that we have across the team of attorneys here.
Yeah.
Let me ask you this. There was this actor by the name of Johnny Depp who had a little lawsuit out there.
Yes.
And around the same time that was going to trial, I think Virginia amended its anti-SLAPP law to make the anti-SLAPP law, a little more robust, not quite as robust as California, but more robust. I'm wondering, with the tightening up of the anti-SLAPP law in Virginia, have you seen an uptick in public interest lawsuits invoking the anti-SLAPP law in terms of protecting free speech?
Yeah, so I knew you were the anti-SLAPP guy, and I knew you were going to go there with me, and I was worried about it because I've not litigated an anti-SLAPP case, nor have I really seen it cropping up in our cases yet. I will say that we recently opened an office in Northern Virginia, like a second headquarters, more or less. Yeah. And we've had a lot of cases we've been litigating here in Virginia and Virginia state courts. So maybe I should be surprised that I haven't seen it crop up as an issue yet, or it's probably something good to have on my radar as an issue that might start to get litigated more often here in our courts. But yeah, not an issue I've seen yet in the cases that I've litigated.
Got it. All right.
Let me go back, Chris, to I had a question for you about when you were in the AG's office. Did you ever have maybe an inkling of your future self as the appellant rather than the appellee? Kind of give you a premonition that maybe there was some error here. Maybe there is some error. Maybe this isn't the greatest case to go forward on. And we talked about how you've been privileged to feel like you were always on the side of the right side of the cause in your public interest work. But did the same go for your work as in the governor's in the attorney general's office? Did you always feel like we caught the bad guy and we got to get the conviction to stand, or did you ever have any misgivings when you were there, and what can you do about it?
Oh, absolutely. And that's an important addendum to put on my answer earlier. So I said I've always felt like the client I was representing was morally in the right with the position that we were taking in court. Now, that doesn't mean that I always believed that the prosecution had been in the right at the trial level, because not all convictions are righteous and morally sound. And there are errors that creep into the process. And so the thing that I loved about being at the Attorney General's office on the prosecution side is that the goal wasn't just to get a win for the government. The goal wasn't just to get every conviction affirmed. The goal really was to do justice. And that was preached from the top down. And so as an attorney litigating these criminal appeals and then also litigating habeas corpus cases, I knew from my superiors that if I found an error in the record that had properly preserved, properly raised and litigated, that I had the ability to write a memo to my superiors and say, you know what, I think we need to confess error here. I think we did get this wrong in the trial court, and we need to either vacate this conviction or send this case back for a new trial. Or in habeas corpus, one thing we did a lot of was giving petitioners a delayed appeal, where they had perhaps asked their attorney to file an appeal, but the attorney had said, no, you don't have a chance, go away, leave me alone, and had dropped that ball. We would often file memos with the Court of Appeals and ask the court to give that habeas petitioner the appeal that he was entitled to that had been denied to him. So I mentioned earlier, like how fulfilling it is as an appellant to get a victory. You really feel like you've made a difference in that case, as opposed to just getting the result below affirmed as the appellee. Same with being a government attorney and at times even getting a conviction reversed or a sentence reduced or a delayed appeal granted to someone who is entitled to one. You really felt like you were part of getting to the right result and making a difference. That if you hadn't been there, the wheels might have just kept on turning, and that unjust conviction or sentence or whatever it might have been allowed to stand. So I was very grateful to be on that side and have those kinds of opportunities and have the support from my superiors to really get to the right result as the law required.
And while you worked in the Attorney General's office, of course, your job wasn't just to work on criminal appeals, but it was also the AG's work is broader than that. I want to talk about a few of the interesting cases you've worked on, both in the Attorney General's office and at ADF. There was the one case, first case I wanted to mention was Turner versus Commonwealth, a case you worked on while you worked at the Attorney General's office in Virginia. This was concerning Virginia's noose statute, which prohibited the display of noose in a way that constitutes a threat. Maybe could you tell us a little bit about that case, how it came out? Because that, it presents an interesting issue there. You are in that case defending the government and the statute in that case, and that it has a rational basis, and against a free speech challenge, or I guess what it's a strict scrutiny analysis because it's faces a free speech challenge, and then I'd like to get Jeff's comments on it too as a free speech specialist. Chris, tell us a little bit about the Turner versus Commonwealth case and how that came out.
Sure. So that was a very interesting case, both legally and on the facts. So factually, it's my understanding that was the first time Virginia had ever prosecuted someone under its noose statute. So we have a set of statutes that prohibit hanging a noose, burning a cross. The cross burning case actually went up to the U.S. Supreme Court in the Virginia versus Black case. I think there's also a statute that prohibits writing a swastika in the same manner, in a way to basically threaten someone and to make them in reasonable fear of bodily harm. And so when we prosecuted an individual who essentially had gotten into a property dispute with a couple of his African American neighbors who lived on the same street as him, and had thrown slurs at them and had been very hateful towards them, and then eventually escalated it to the point where he hung basically a dummy in effigy from a noose in his front yard, where those families, driving by every day to get to their home, or their kids walking by his house to get to their home, had to walk by it every single day. And because of their past interactions with him, this individual, they took it as he's threatening us. This isn't just someone trying to express an opinion or doing something of that sort. This guy means business. And so we had testimony from the families about how they were afraid to leave their house and worry about, whether they're going to be at risk walking up the street. They were afraid to let their kids, walk to play with their neighbors outside. So we brought the Commonwealth attorney brought the lawsuit, and then got the conviction. It got appealed up to the Court of Appeals. At the time, the Court of Appeals only took cases by petition, so they granted the petition, realized these First Amendment issues that the defendant was making were important issues to litigate. And I was able to work pretty closely with our state SG section in writing the brief, prepping for oral argument, litigating that case to the Court of Appeals and the state Supreme Court.
Were there any public interest law firms involved for the defendant in that case? Free speech
Sure.
firms?
There actually weren't. And doing what I do now, it does make me, I'm almost surprised by that there wasn't a little bit more attention given to the case by public interest groups. However, having litigated the case, what I could say once I dug into the issues, at the outset, you think, wow, this is a difficult First Amendment issue of, is this the sort of speech that we can prohibit, or, is this just hateful speech that the government doesn't like? And once you give the government the ability to, outlaw all speech it doesn't like, that's a pretty scary place to be in terms of slippery slopes. And what I realized was that the General Assembly in Virginia really did a good job writing the statute in a way that it perfectly tracked the U.S. Supreme Court's case law on what constitutes a true threat. And so because of that, it was pretty narrowly cabined to only criminalize this sort of hanging a noose, burning a cross, in a way that really does put someone in reasonable fear of harm to their lives, and cases where that was the defendant's intent. He was trying to threaten the person who was going to be the recipient of that message. So I was able to get the conviction affirmed on First Amendment grounds in the Court of Appeals of Virginia. And then in the state Supreme Court, the defendant actually dropped his First Amendment claim and turned it into just a statutory interpretation case about what constitutes a public place and whether his front yard is a public place under the statute. And we were able to persuade the court that it does, and it did, and get the conviction affirmed there as well.
Any First Amendment commentary on that one, Jeff?
I don't think there are First Amendment concerns in the context of an intention, a jury finding of an intention to intimidate,
Right.
A noose in the city, in front of the Capitol in Washington, D.C. without context is First Amendment protected. But that noose with an intention to do harm somebody inside the Capitol, there might be a violation of the law there. So And I think I'd read a couple of opinions that said maybe this issue wasn't even properly briefed or preserved in one of the appellate decisions I read. So wasn't really a meaty, substantive discussion of the First Amendment in this case.
It was a very interesting case and fun case to litigate, and it appeared much more interesting on the papers when it got to my desk. Because I did think it was going to be a difficult First Amendment issue. But it was a case where the General Assembly had just done such an excellent job drafting the statute, which you don't necessarily always see that statutes are drafted perfectly to fit with constitutional constraints.
Right.
But here we did. And so that made litigating the constitutional issues much easier on the side of the government, and also gave me a lot less heartburn about, doing some sort of greater harm to broader First Amendment interests in other cases.
Right. Yeah.
Okay, Chris, I also wanted to talk about another case you worked on while working at Alliance Defending Freedom, Hoggard versus Rhodes. This is a case that involved a student in a lawsuit against university officials after the university had sent campus police to shut down the students' table outside the student center that was recruiting students for a conservative student group. And the Eighth Circuit in that case had found that there was a First Amendment violation, but that the university officials had successfully asserted a qualified immunity defense. And tell us what happened in that case, and especially how you wound up getting Justice Thomas to write a statement that I think was not in an opinion. I wanted to ask you if this comes from the shadow docket, but it's basically a cert petition was denied, but you wound up getting a very quotable statement from Justice Thomas that's been cited in many opinions since then.
We did. So we were very, obviously we were hoping to get a cert grant in that case. I know there've been a lot of cases pending in the U.S. Supreme Court in recent years trying to get the court to address this issue of qualified immunity, which is really just this judge-made doctrine that protects government officials when they violate the constitutional rights of their citizens, unless there's what's called clearly established case law. But what the courts have read to mean, unless there's a case that's almost identical on the facts that was decided previously in the same jurisdiction, you can't hold that government official liable for violating someone's constitutional rights. And so we represented this college student. She was trying to start a conservative student group on her college campus. So she set up a table outside the student center and was just basically signing up names. Anyone who wanted to join her group could stop by the table, sign up their name on a clipboard, and she'd give them some candy and they'd go on their way. University officials called the police to remove her from that section of the patio outside the student center because she was not yet a recognized student group, she was not allowed to be there gathering signatures that she needed in order to become a recognized student group. So we felt like that was a violation of her First Amendment right to be there in a public place on state property at a public university. Filed suit on her behalf. The Eighth Circuit, like you said, agreed with us that the school had violated her First Amendment free speech rights, but because there was no case in the Eighth Circuit that looked exactly like this one, they were not going to hold those public officials liable for that behavior. And so our cert petition, just to kind of close the loop on that, our theory behind the cert petition was, it's one thing when you're dealing with police officers who are on the street making split-second life or death decisions. I can understand the courts not wanting to second-guess those and the potential ramifications of that. But when it comes to university officials kind of sitting back in their ivory towers and coming up with, speech codes and speech zones and all of those things, why should they get the same kind of deference when they violate their students' rights that we're giving to police officers? So that just didn't make any sense to us. We teed it up as a question presented for the U.S. Supreme Court. The court, like you said, didn't grant cert, didn't reach it, but Justice Thomas, in a statement he issued respecting the denial of the cert in that case, did say that the court really needs to take a case like this to clarify why it is that qualified immunity applies the same way to university officials that it applies to police officers.
Yeah, and the Justice Thomas's quote here in the statement respecting the denial of cert basically adopted your argument. The quote is, why should university officers who have time to make calculated choices about enacting or enforcing unconstitutional policies receive the same protection as a police officer who makes a split-second decision to use force in a dangerous setting? And he says, we have never offered a satisfactory explanation of this question. We should reconsider either our one-size-fits-all test or the judicial doctrine of qualified immunity more generally. And you mentioned that that's been cited close to 100 times already.
Close to 100 times already, which I think is pretty impressive for a statement respecting denial of cert, right? It's just
what a total failure you are, Chris, for failing.
Failing to get cert on that case, right? I mean, and the challenge in some of these cases is, especially qualified immunity, right? So in the circuit courts, you have to argue, this is clearly established. This is clearly established. Look at how easy of a case this is. Look at all this case law that you have on this issue. And then if the court says it's not clearly established, then you have to go to the U.S. Supreme Court and say, oh, this is this unsettled issue that you should take up now. And so the briefing strategy really has to change quite fundamentally between the work you're doing at the Circuit Court of Appeals and the work you're doing in the U.S. Supreme Court. And we think, I mean, that is true to some extent in any case you're filing a cert petition in, but particularly in this qualified immunity context, it really makes things difficult on the litigants.
Chris, can I ask, I haven't followed this debate very closely about qualified immunity. Is this considered like a conservative cause or a liberal cause to re-examine this doctrine?
So I think it's interesting that it's an issue that really goes across, ideological splits. So we've filed briefs in support of cases brought by folks that ideologically are to the left of us, and we've had folks ideologically to the left of us file briefs in support of our cases on these issues. Typically, folks who lean left, their concerns tend to be, police abuses that we've seen and how qualified immunity gets applied in that context. And I share a lot of those same concerns in the way that the doctrine plays itself out. But typically you'll have, the law and order judges who, don't want to touch qualified immunity in that context, but might be more amenable to an argument that, even assuming it makes sense in that context for police officers, why are we applying it the same way for government officials who are sitting back and setting policies, restricting free speech rights? And so that's where you really see the ideological divide kind of dissolve, and folks on kind of both sides of the spectrums coming together, asking the court to do something about this. So we remain optimistic that at some point they will.
It's interesting. I've had two friends suffer some injuries from law enforcement, and these friends look like me, old fat white dudes. Mm-hmm. And both times the courts avoided reaching the merits of the controversy under this doctrine when I think some scrutiny was merited. It's interesting. Right.
And that's the other downside of the doctrine, if I could just make one more point on it. So under a U.S. Supreme Court decision, so it's a two-part test. Was there a constitutional violation, and was that violation, quote unquote, clearly established? Right. But the Supreme Court has said courts can do that in any order they want to. So they can first, instead of asking was the law violated, they can say, well, was it clearly established, assuming it was violated? And if they say no, it wasn't clearly established, thus we don't need to decide whether or not it violated the Constitution, then the law never gets clearly established, and you're just stuck kind of spinning your wheels. So that's another problem with the way the doctrine is played out that we're hoping the court will address at some point.
Interesting. Yeah. That is a crossover issue, and I'm glad it is, because when something is just branded as that's just a conservative issue or that's just a liberal issue, then it tends to get short shrift. But once it becomes a crossover, then maybe people start taking a more serious look at it and address it in a principled manner rather than some sort of lopsided manner. They'll just appease one side of an issue. One other question, Chris, about Justice Thomas's statement here concerning the denial of cert in the Hoggard versus Rhodes case. Would this be an example of the shadow docket? Does Justice Thomas's statement there with respect to denial of certiorari, does that come from the shadow docket? I put that in scare quotes because it's mostly just a made up term, a neologism. But it's Yeah.
It depends on how you define shadow docket, right? So the U.S. Supreme Court has always had an emergency docket where cases come to them on kind of an expedited basis and have to get decided very quickly with not a lot of briefing, no oral argument. And so when you hear the phrase shadow docket, I think it's typically referring to those kinds of cases where the court does make a decision kind of on the merits of the case, either to stay a case or to grant an injunction. So to some extent, a decision that does at least touch on the merits to an extent. This statement by Justice Thomas was not on the emergency docket. It's just a statement that he issued on the traditional cert seeking process. You file your cert petition, they grant it or they deny it. If they deny it, justices will sometimes write an opinion either dissenting from the denial or they'll issue a statement explaining why they might have agreed to deny the petition. But these are some things the justice just wants to have on the record. So we were, if you want to loosely define shadow docket, you might say that this was, but I think the technical emergency docket definition, maybe not.
Refers to the emergency docket.
Maybe this is a penumbra of the shadows. I don't really know. I don't have my terminology nailed down.
Well, I was just going to ask if it's so easily found and cited up to nearly 100 times already. It's not really in the shadows. But
that's right. We're doing our best to bring as much light to it as we can. That's for sure.
There you go. All right, and then the last case we'll briefly touch on. Kligler versus Attorney General. This is another one of your cases that you worked on with Alliance Defending Freedom. You did the oral argument in this case. This involved the Euthanasia Prevention Coalition USA. You represented them as an amicus in the Massachusetts Supreme Judicial Court in defense of Massachusetts common law prohibition on assisted suicide. And tell me a little bit about your involvement in this case. And just to shortcut it, it sounded like this case was the case was dismissed on a motion to dismiss, and the Massachusetts Supreme Court ultimately reinstated the case and sent it back. It was interesting watching your oral argument on that, but I don't want to get ahead of you on that. Tee that up a little bit for us, and because I want to ask you about your experience in the oral argument there, because it was a very hot bench there. You had almost everyone on the Massachusetts Supreme Court had a question for you, and definitely had a point of view on the case. And I want to know how you were able to address all that, and whether that was expected as merely an amicus in the case and not one of the actual parties.
Right. So it was certainly a unique experience as an amicus, getting to get oral argument time in that case and getting as much time as I did. So just to make one quick clarification at the outset. So the state Supreme Court actually affirmed the decision below, and the decision below was that there is no state constitutional right to assisted suicide. So the state Supreme Court agreed with our position as an amicus that the state constitution doesn't have some right to get a doctor to prescribe you lethal drugs that you can then go and take on your own to commit suicide. So the way that we initially got involved in the case, so we do kind of monitor state courts and federal courts across the country just to have a good sense of what issues are being litigated in some of our core practice areas. And this is certainly a case that fits within that mold, the type of case that our life team would be litigating. So when we saw the case was going up to the state Supreme Court, we immediately thought, the governor was defending the law, the attorney general was defending it. So we thought, well, we'll file an amicus brief supporting the defense of that common law prohibition on physician-assisted suicide. And as I dug into the case a little bit, I kind of realized, while the state was defending it, and we appreciated that, there were definitely some arguments that could have been made that weren't being made, that were kind of being left on the table there. And so we decided, instead of your traditional amicus brief where you kind of make some policy arguments maybe, or some arguments at the margin, we're going to file essentially a merits brief and lay out what we think are the strongest arguments as to why there's no right to this in the state constitution. So we did that. We filed the brief. And I was talking to my boss afterwards, and I was telling him, I'm really pleased with how it turns out. I hope they read our brief because I think we make some good arguments that are going to get missed otherwise. And he said, well, why don't we think about filing a motion to get you argument time before the court? And my first thought was, can you do that? Is that, do they let amici come in and argue cases? And he said, well, the worst they can say is no. So we filed a motion, didn't hear anything about it, thought that it was water under the bridge. And literally 2 days before argument, I got an order from the court granting the motion, telling me fly up to Boston and do this oral argument. I got the notice on Monday. The argument's on Wednesday. So it was a whirlwind of prepping for that, getting the flights, getting up there to do the argument. And the argument itself, as you said, was a very live bench and a bit of a whirlwind in and of itself.
Yeah, you had to have your head on a spring because you just had to keep toggling back and forth to different judges peppering you with questions.
Yes, and I'll tell you. So I talked to someone afterwards who was in the courtroom, and they said, "Man, I'm so sorry you didn't get to make any of the points that you wanted to make because you were up there just answering questions the whole time." And in my mind, I'm thinking to myself, actually, I made every single point that I wanted to make in the course of that 20 minutes, but I was able to make it in the course of having a conversation with the justices and answering their questions. And as an appellate advocate, that's really the dream, the ideal. That's what you want to happen. You want it to be a conversation where they are genuinely interested in your answers and asking you questions because they want your help in getting to the right result. And I never practiced before that court, but I have so much respect for the justices there now, having been through that with them, because you could really tell that they were seriously engaged and interested in just getting to the right result and getting as much help from the advocates in front of them to help them reach that right result. So I was thrilled and honored to get to be a part of that.
You could tell even at one point, I thought one of the justices seemed like he wanted to get under your skin a little bit or to jar you loose and said, "Well, counsel, obviously you're very practiced in your arguments, but what about the sympathetic argument? What do you say to this doctor on a personal level?"
Right.
What's going through your mind when you notice that a judge is trying to get you off your script, off your talking points, out of your comfort zone? Do you indulge and go out of your comfort zone, or what's the best approach there in your view?
Yeah, so I always take the approach, I never write off a judge or a justice going into argument as unpersuadable. I've just decided, other attorneys, maybe I haven't been doing this long enough to be as cynical as some might become, but I'm going to have that assumption that every judge or justice is there because they want to get to the right result, and they're open to getting to the result that I'm advocating for. Yeah. So when I hear that from a justice, my initial thought is honestly not that they're trying to throw me off, but that he clearly had problems with the arguments that I was making and had some really deep concerns about the implications of the result that I was asking for. So I appreciate hearing that from a justice. I want them to air that with me and give me an opportunity to address it and respond to it. Because if they have those kind of concerns that are preventing them from ruling in my favor, I mean, who could ask for a better opportunity than to have that conversation there in the moment before that decision gets made? It's a scary thing. Your mind goes, what do I say to kind of help diffuse this and kind of move the justice where I want him or her to go. But I just kind of try to, calmly give the best answer that I can, not get offended by the hard questions, and give a response that hopefully helps to make my case while also addressing their concerns. And I'll tell you, if you had polled me after that argument and asked me to guess which of the justices were potentially for me and which were against me, I would have ranked that justice pretty heavily against me based on that particular exchange. And when the opinion came out, we won his vote on our side of the case. So it was a good affirmation of the approach that I try to take of just not writing off justices and treating them reasonably and assuming that they are open to persuasion and just interested in getting to the correct result.
One question that we like to ask advocates is about the nascent trend of tentative decisions or focus rulings by a panel, where an appellate panel will let the parties know these are the issues that we would like addressed during oral argument. Can you give us your opinion on that? Is that good, bad, or indifferent? Does it help you for oral argument? Would you rather be surprised and just answer the questions cold on the right there at oral argument?
Yeah, so I guess I've never experienced either. So I've never seen a draft decision released to the parties before argument. I mean, to me, that's rare, and it was shocking to me that was a thing that happens out there in California. And so you can confirm that is a thing. You get a draft of the opinion before. Wow.
There's one court in specifics, Division 2 of the 4th District, out in Riverside and San Bernardino. They give you the draft opinion, and then you decide whether to request oral argument or not.
Okay.
There's some divisions in LA, the second district, that will give you a verbal. So I've had 2 or 3 occasions in the last 3 months where I've gone to oral argument. Before I can get one word out of my mouth, it's, Mr. Lewis, we preliminary agree, or Mr. Lewis, we preliminary disagree.
Right.
And here's what we want to hear.
Okay.
Yeah, it's a thing here in California. Yoga, kale, and tentative opinions.
Right. Not a thing here in Virginia. Not something that I've seen. The closest I've seen, a colleague of mine at the AG's office, he stood up as the appellee on behalf of the Commonwealth to give his argument as to why the conviction should be affirmed. And the judge, I guess, gave the oral. The presiding judge said, Mr. And it's funny, my boss's last name was Judge, so it got very confusing. The judge said, Mr. Judge, if you sit down if you don't say anything, we're going to rule in your favor unless you mess it up. So he turned back around, walked to counsel table, and sat right down, didn't say a word. Yeah. And the opinion came out that way. So I don't know. I think that I would not love the idea of seeing the opinion ahead of time, because I think there's real value to be gained from the oral argument itself. I know a lot of people don't think that oral argument adds as much value. Maybe I'm young and idealistic still, and I think that it can on occasion. So I'd want to have that opportunity to make my case before the judges at argument. The focus letter, I think I'm more open to that being something I would appreciate. If the judges want to really focus on 2 or 3 issues, knowing that ahead of time would be helpful going into the argument. But yeah, I guess if the opinions were always in my favor going in, I guess it would be nice to know that. But being on the receiving end of that, that would be hard.
Yeah.
Yeah.
There's a quote about writing that I've always liked, that writing is the art of the second thought. And I thought that could probably be applied to appellate advocacy writ large, that appellate advocacy, good appellate advocacy, is the art of the second thought. It's looking at the case another time with a second set of eyes. And if that were applied to questions at oral argument, that a good answer to a question at oral argument, in any kind of question that really bears on the outcome of a case, the best answer is one that involves a second thought, not just the off the cuff response that, this fits into my talking points. But going back to what you said a minute ago, really trying to understand what the justice is, what problem the justice is trying to solve, and not just the answer that is going to get me off of the of this pointy stick that the judge has just prodded me with, but really get to the solution that's going to help this justice, write an opinion in my favor. Much easier to do that if you have time to give it the second thought. But I wonder, what are your thoughts on that? Is the tactic just to try to anticipate all the questions and develop your second thoughts before you walk into that room?
Sure. I mean, the goal definitely is to anticipate as many of them as possible and go in having those second thoughts ready to share with the judges and the justices. I mean, I think the reality of brief writing, in a perfect world, we would write perfect briefs and we would cover all the issues and all the concerns, and the judges would read them and be persuaded one way or the other. But the reality is, I don't write perfect briefs. I have holes in my arguments sometimes that I don't know are there, or I have page limits that force me to not cover some issues to the extent that I'd like to, or maybe I'm writing for a majority of 5 justices on the court, but I know there's going to be another 3 or 4 that have concerns that I can't fully flesh out in my written product. So having the opportunity to go to the oral argument and have conversations about those things that are left open or left unresolved by my written product, I just think is so incredibly valuable for the judges and the justices, and I think hopefully too for the advocates, that we go into them viewing them as an opportunity, and not just viewing them as a scary exercise where we're hoping to avoid snatching defeat from the jaws of victory, as I've seen attorneys do. Right, that we could approach them differently, and I think they could be a lot more productive, perhaps.
Right. Well, so it sounds like the answer to both the questions, do amicus briefs matter and do oral arguments matter, are answered in the affirmative, and you brought receipts for both, and it's the same case, Kligler versus Attorney General, where you were the amicus and you gave the oral argument that appeared to have made the difference. So congratulations on that case. Well, Chris, you had some other questions that you're going to answer, or some briefing myths.
Yep.
You mentioned that you had a list of top 10 briefing myths that I thought we would close by discussing those. And there are a few of them. Many of them I think Jeff and I have probably both agree with. There's a couple I had some questions about, but let's just get right to it here. So Chris Schandevel's top 10 briefing myths. I'll just tee them up here and have you explain. Myth number 1: it's best to make your brief look like most briefs filed before your court. When I first read that, I thought, that's a myth?
Yeah, so this...
tell us why that's a myth. It's a myth that you should make your brief look like most briefs filed in your court.
Yeah, so this is where we get to the controversial part of the podcast, right? We start busting some brief writing myths, and I'm hopefully we'll get some feedback from your listeners on some of these. So when I started practicing law in the state AG's office, I started looking at the briefs my colleagues were writing, and I started to realize these briefs all kind of look similar. Similar practice had kind of grown up over the years of just what our government briefs look like. But you compared them to some of the briefs written by the professional, printers that some of the private parties used, and our briefs were kind of ugly. They were dull, they were dry, they were boring. The cover page, looked like we just scratched it off the typewriter in a few minutes. And so I said, you know what, our briefs should look better than this. And so I played around with Word and threw in a couple of bars on the top and the bottom, and made my font a little fancier for the Supreme Court of Virginia and things of that sort. And then I noticed that trend kind of catch on within the office of more attorneys were kind of using the same formatting that I was using for their briefs. So our briefs started to look a little bit nicer. But I think that's true, not just in the office that I was in there, but attorneys tend to be creatures of habit. We tend to keep doing the same thing the same ways for a long time. And oftentimes the temptation is just to copy what everyone else has been doing because that it's safe. We can be pretty risk averse folks. So if everyone's been doing something the same way for a long time, maybe that must be right and acceptable. So I'll just do it the same way. But there are real downsides to that approach because you miss opportunities to make your briefs look nice, to look readable. If you just default to the same font choice or the same style choices as everyone else. The caveat I'll give is that there are definitely attorneys who do it well and do it a lot. So my advice would be, don't just look at what most attorneys who practice in the court do in terms of structuring and formatting their briefs. Find the attorneys who are there a lot and who are well respected practitioners. For me, oftentimes that's state SGs. They're before those courts on a regular basis, and they tend to have really nice looking briefs, well formatted, follow all the rules, etc. But in terms of your common practitioner, a lot of folks, as you all know, a lot of times really trial level attorneys just kind of following their own cases up to the appellate court and just kind of doing what worked for them below. That's not always the best approach. Yeah.
So if you're going to copy someone who's doing it at the top of their game, rather than just pulling out a brief.
Yeah.
What's the last brief that we filed 10 years ago? Let's just pull that out and without thinking file the next brief that looks the same way.
Right, exactly. Yeah, so not as controversial as it sounds, perhaps, but that's the advice.
Yeah. Okay. Now, myth number 2. I think we're going to have some people log off. Myth number 2: Times New Roman is an acceptable font choice. That's a myth. Tell us why Times New Roman is not an acceptable font choice, Chris.
That is a myth, and I should say by not acceptable. That doesn't mean that you're going to get sanctioned by a court if you use it. You can get away with using Times New Roman, but anyone who's taken the time to actually study font choices, the Seventh Circuit Court of Appeals put out an excellent primer on formatting briefs that I recommend to anyone in your audience listening to check out. You can Google it and find it pretty easily. What you learn is these fonts were developed with specific purposes in mind, and Times New Roman was developed for newspapers. And it was the letters are kind of crammed together in a way that allows for the typesetter to fit more words on the page in those little columns that they have on the newspapers, and also designed in such a way to make it easier for the reader to skim the headlines, skim the front page article, and get through that paper as quickly and efficiently as possible. at least for me as an appellate attorney writing briefs for judges, I don't want those judges skimming through my briefs as quickly as possible, right? So I don't want to choose a font that's like forcing and encouraging them to read my brief more quickly. I want a brief that's going to encourage them to slow down, really sit and understand the arguments.
Yeah.
And
Skimming the brief is not the same as readability. If a font is designed for skimmability, that's not the same as readability.
No, it's not the same as readability. So Century Schoolbook is my favorite font choice. And the fact that the word book is in the name of the font is your clue that it's a font that was designed to be used in books. Books are meant to be read. Books are meant to be really digested fully and deeply. Exactly what you want the judges to be doing with your brief. So that's why don't choose Times New Roman. Don't encourage your judges to skim through your brief. Pick a font that will encourage them to slow down, understand your arguments, and hopefully rule in your favor.
Okay. An addendum to that, or follow-up question to that, what about trial court briefs? The same thing apply? Would you use Century Schoolbook in a trial court brief?
Absolutely. Yeah, we have an internal style guide that we suggest Century Schoolbook for all of our trial level briefs. And again, so judges are busy. So there might be temptation to say, well, I'll just give them a skimmable brief so they can read through my brief more quickly. But no, you want to fight that urge, give them something that will help them slow down and really grasp and understand your arguments. You might want to write a shorter brief to take less time out of their day, but you want them to read it carefully and pick a font that will encourage that.
All right. Well, we're running a little bit long, so let's power through the rest of these. Myth number 3, 2 spaces after periods is an acceptable choice.
Yeah, it's just
Chris, why is it not acceptable to use 2 spaces after a period?
Yeah, so the best advice I can give you is open a book and look and see how many spaces are after the periods. All professional typesetters pretty universally agree that only 1 space should go after periods. It's just kind of universally accepted. For some reason, attorneys, being creatures of habit, we have fought that. If you want to talk about like the practical impact on using 2 spaces, I think some attorneys will say, oh, it looks nicer, it spreads out my sentences. But the reality is it kind of slows down the reader and forces some extra pauses in there that you might not want. So there's other ways to space the brief, the pace of a brief, without throwing all those extra unnecessary pauses.
What about extra spaces in between paragraphs?
So I am an advocate of no extra space in between the paragraphs. I want my paragraphs to flow one from the other. Sometimes I'll do a little bit of extra space on top of a point heading when I'm starting a whole new legal argument in the brief to kind of separate those out. But yeah, paragraph and paragraph, I'm going to do everything I can to connect those paragraphs using words like and but and so. And so extra space, I think, would counteract that, in my opinion.
Okay. Myth number 4, initial caps is acceptable for point headings. Chris, why is it wrong to use initial caps for point headings? It
is wrong. And it again goes back to, if you want your judge to read and understand what you're writing, and of course you do. So if you're writing good, complete sentences for your point headings, especially in your argument sections of your brief, as you should be, the point head, if you use initial caps, that trains the reader. We're used to seeing, 3 or 4 word phrases with initial caps. So the reader immediately senses, oh, this is a phrase, because it's an initial cap. So the reader reads the first 3 or 4 words and thinks, oh, but there's more. There must be another phrase. Well, is this a new phrase? If you're using complete sentences like you ought to be, you want the reader to know that based on the fact that you're not using all these initial caps and confusing the reader.
That's good. I haven't heard that explanation for it before, but that makes a lot of sense. What about can you use topical phrases? Like if I'm doing the procedural history of the case, can I have a subheading that says summary of the district court's order and put that in title caps?
Yeah, so I will do some of that in the statement of facts or statement of the case. I'll use more topical headings there. My argument section is always, every point is complete sentences. And it has to do with another big thing that I'm big on, which is storytelling. You want your table of contents to tell the full story of your case. And it's just much easier to tell a complete story of your argument when you're using complete sentences. You can kind of get away with telling a story in the facts with some phrases inserted in there. But for the most part, even in the statement of facts, I tend to prefer the complete sentences to tell that story.
Okay. Myth number 5, Microsoft Word's double spacing feature is true double spacing. So if you want to double space your brief, you just hit the double spacing button in Microsoft Word. Is that right or wrong?
Yeah, little did you know, Microsoft Word has been lying to all of us. Microsoft Word double spacing is not true double spacing. They add an extra 15% or so of white space in between the lines. So you get a lot more space in between your lines on the page than you ought to be getting if you're doing exact double spacing. And the downside of that is it just makes it harder on the reader to move from line to line as he or she is reading your brief, easier to get lost. And so we set all of our briefs in exact double spacing, which means we go into the paragraph settings, we get out of the double spacing that Microsoft Word sets, and we click that exact button, and then we'll set it to ×2 of whatever font size we're using. So if we're in 14-point Century Schoolbook, we'll set it to exactly at 28 point. And again, it just improves the overall readability of the brief because you don't have all that extra white space in between. I will add caveat, check your local rules. All of these myths, if a local rule trumps advice that I'm giving, you want to go with local rules, obviously. So,
Yeah.
Although, if the local rule says use Times New Roman, you should take a bar and go to a different jurisdiction. Take a different bar exam.
You should probably look up whoever's writing those local rules if your jurisdiction says that.
All right. Myth number 6, a shorter brief is always better. Chris, is that wrong?
I think it's wrong. And, maybe I'm unique in that I get to argue a lot of constitutional issues of first impression. But, I think if I turned in like a 15-page brief for some of these giant issues of, I've recently briefed in the Virginia Supreme Court whether their free exercise clause is more protective of religious freedom than the federal free exercise clause, and I had to go through a couple hundred years of history in order to make my arguments. If I had turned in a 15-page brief without all of that history and just said, you're on your own court, go look it up yourself, I have a feeling that, the law clerks might have appreciated a short brief in the reading process until they then had to go and do all the legal research themselves, and might have liked to have gotten more from me as the advocate on that. So I think that, brevity is valuable, but like anything else, it's a tool that we're given, and the ultimate goal is persuasion. So if persuading the judge to do what you need them to do means you have to write a little bit of a longer brief on occasion, then you should write that longer brief if it increases the odds of persuasion.
Yeah. Your brief should be exactly as long as it needs to be and not a word longer.
Exactly right.
All right. Myth number 7, you should structure your brief in the same order as the opinion you're appealing from, or if you're the appellee, in the same order as the appellant's brief. So if the order you're appealing from is raises points A, B, C, D, then your brief should just be A, B, C, D. But that's not right, Chris?
I don't think that's right at all. Right. So, it's such a struggle as a young attorney. The temptation for me was always, I'm the appellee. I'll see what the appellant's arguing, and I'll just plug in my responses to each of those point headings, 1, 2, 3, A, B, C. The problem with that is if they're doing their jobs correctly, they're leading with their strongest arguments, which means that if you're following their approach, you're leading with your weakest arguments, perhaps, instead of leading with your strongest. So I always say, start with the strongest, lead with those. The caveat being if there's a threshold issue, standing or something like that the court is likely to really be hung up on, you might have to lead with that argument just to clear the underbrush and get that out of the way. But for the most part, pick your strongest arguments, lead with those, and then refute the other side's arguments on the back end.
What if the panel is just really itching to know your response to their strongest argument? Does it look like you're being evasive if you drop it down to the end?
No, I think that's something that would be hashed out at argument, right? If up at oral argument, it's clear that the judges really want to talk about this other issue first, and I had saved it for last. I'm going with them, and we're going to spend the first however many minutes they need to on that argument. But in my brief, I'm the master of my own brief. I get to lead with the stuff that I think is the strongest.
There you go. Myth number 8, you should never, ever start a sentence with a conjunction. Chris, that's wrong.
My first grade teacher might be surprised to hear that I think that's wrong, because I think a lot of us learned back in grade school that that's not an okay thing to do. And again, go back to the advice I gave on 2 spaces after periods. Pick up a book, pick up a magazine, look at all the conjunctions that are starting sentences over and over and over again. I think our first grade teachers were trying to beat out of us the practice of, little kids like to say, and then this, and then this, and then this, and then this, right? And so it was a reasonable approach, but unfortunately we've taken it too far, and our briefs are much less readable because we don't think we're allowed to start sentences with ands and buts and so's. And so I'm all about using those connector words at the start of sentences.
Yeah, so the same grammar rules that apply to kids in grammar school don't necessarily apply to us attorneys.
Right, exactly. And probably if we were paying more attention in grammar school, our grammar school teachers would have said, this isn't actually a grammar rule. I'm just going to help you write better. But we seem to have missed that part. And now we blame our grammar teachers for how we write.
Myth number 9, you should never ever use contractions in legal briefs. But that's wrong too, huh, Chris?
I think it's wrong too, and that one might be a little bit more controversial. I don't use them often, but I will say I probably use them in just about every brief I file, whether it's the state Supreme Court, federal Court of Appeals, U.S. Supreme Court, probably only a handful, 2 or 3. But for me, it goes back to readability. There are some sentences that just read more naturally if you include a contraction. And this no contractions ever rule leads attorneys to bend over backwards to rework and rewrite and reorient sentences to make them read a way that we can avoid using that contraction, when the easiest approach would just use the contraction and move on. And you would gain a lot of readability, I think, by doing that. And I'll give you a quick example. I'm a big fan of short, punchy sentences to really drive home points. And one of my favorite short, punchy sentences is when I'm following a point made by the other side. I'll say the government argues X, and then I'll say, but that's wrong. And then I'll explain the reasons why it's wrong. If I were to change that and say, but that is wrong, it just loses some force and some punch and some naturalness to it. So I'm a fan of including some contractions, used sparingly and used appropriately where it helps.
Right. Okay. And myth number 10, substantive footnotes and explanatory parentheticals are signs of good legal writing. That's a myth, right, Chris?
I think that's a big myth. And yeah, when you first start reading legal writing, you might just assume that, I need to lard this brief up with tons of big footnotes and lots of large explanatory parentheticals for all of my case cites. Again, go back to readability. You want your brief to read like a good book. It's not going to be as interesting as a good book. We're practicing law, so we can only do so much within our limitations, right? But to the extent that we can make it more of an enjoyable read, the better. And one of my favorite kind of examples to drive home the point about footnotes, forcing a judge to sit there and read a good brief, if it's a well-written brief and she's reading along and enjoying the brief, forcing her to then, jump down and read a big substantive footnote and then jump back up above the line to read the good content that she was just enjoying from your brief. The analogy I've heard, it's like having to run downstairs to answer the doorbell on your wedding night. Like, you just don't want to force the reader to interrupt the good flow of your legal writing that you were given that reader by sticking a bunch of stuff in the footnotes. So I try to avoid that as much as I can.
Yeah. I don't like darting my eyes up and down, up and down. Sometimes I get lazy and I see, okay, there's a footnote. I'm just going to keep reading. And then before I turn the page, I'll just glance and see what's down there.
Right.
And then it disrupts the flow either way.
Absolutely. Yeah. So to the extent that you can, I had a mentor who reviewed all my legal writing when I started writing briefs. And I can't tell you how many times on my paper, on my briefs, I get back in big bold letters, above the line. She was always making me move stuff up above, and that stick with me.
Yeah. All right. Well, we're gonna. That's gonna serve as the lightning round for today because you gave us all your grammar tips.
No, we're gonna have an abbreviated version of the lightning round. We are running low on time, but we're gonna have an abbreviated version. One question. Right. Are you ready?
Let's do it.
Cleaned up. Your 3 choices are everybody should use it, lawyers and judges, judges only, or nope, no cleaned up anywhere.
Everybody should use it. Absolutely. I am a huge fan of the cleaned up parenthetical. I don't know. I'm a fan of following the Blue Book generally, but when following the Blue Book decreases readability of my briefs, I think it hurts persuasiveness and gets in the way of what I'm trying to accomplish as an advocate. Now, granted, it has to be used correctly, and so my fear is that attorneys are using it to make substantive changes and just saying, cleaned up, and not showing their work. It cannot be used in that sense, but in terms of dropping a bracket or dropping a quotation mark that you don't need, I'm all in favor.
What a great barometer for either a law clerk, research attorney, or judge to just take a test to see if this lawyer has credibility. Take a couple of cleaned up quotes and see, does it really say what he says?
Absolutely. I think you have to earn your right to use that cleaned up parenthetical by using them responsibly and credibly. And once you've shown the reader that they can trust your use of those cleaned up parentheticals, you're good to go.
Has it popped up? It's popped up, I think, once or twice in a U.S. Supreme Court case, and it's popped up in one California published case. Has it popped up in any Virginia published decisions?
I haven't looked at Virginia specifically to see if they've started using it yet. I'll have to see. I'm expecting a decision from them by the end of June, and I certainly used it a lot in my briefs. So we'll see if any of that rubbed off on whoever's writing that opinion.
Okay. Well, as we wrap up here, anything you else want to add that you think our audience might be interested to know about you or the way you approach appellate law?
Just that I can't thank you guys enough for having me on today. It was a blast and a thrill. If there's anyone out there listening who either does appellate law and wants to just nerd out with a fellow appellate attorney, or someone who's not yet in the appellate law space, maybe a young attorney or someone looking to make a shift, find me on LinkedIn, reach out to me. I'd love to chat. I'd love to be of any help to any of your listeners as I can on those fronts. So I always enjoy talking about this stuff, and I'm so grateful that I got a chance to do this with y'all here this afternoon.
Likewise, thanks, Chris. And I like your motto about cleaned up, use responsibly.
That's right.
And that's going to wrap up this episode. Again, we want to thank Casetext for sponsoring the podcast. Each week, we include links to the cases we discuss from Casetext's daily updated database of case law, statutes, regulations, codes, and more. Listeners of the podcast enjoy a special discount on Casetext basic research at casetext.com/calp. That's casetext.com/CALP.
Yeah, and if you have suggestions for future episodes, please email us at info@calpodcast.com. Please only use Times New Roman single spaced. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right, see you next time. Thanks again, Chris.
Thank y'all.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.